Open the court, Mr. Chipstaff.
All persons having business before this honourable court are commanded to give their attendance. They shall be heard. God save the Queen. We sit.
Now, my viewers, that was the retiring Chief Justice of Victoria, Marilyn Warren, opening a ceremonial sitting of the court on the occasion of her retirement. Immediately to the left of her is the President of the Victorian Court of Appeal, Christopher Maxwell. For those of you who care to watch, you will witness significant history in the making. Now, don't let the pomp and ceremony of that little show delude you. As I will shortly show, the justice system, including the Supreme Court and the Court of Appeal, are in fact cesspools of corruption, where the courts and the judges and barristers maintain their sham good name and social status by authoritatively denying and concealing the rampant corruption of many barristers and solicitors who scam people by bringing scam and sham proceedings to court. As I will demonstrate in this video, back in 2006, 7, 8 and 9, 6 judges of the Supreme Court of Victoria and the Victorian Court of Appeal chose to pervert the course of justice and sacrifice the democratic and human rights of myself and my family for their notion of the great good of protecting 7 scamming barristers and solicitors and maintaining the in fact sham good name of the court, the scammers and themselves. 2 of those scammers were the now Major General Justice Greg Gard and the now Federal Court Judge Justice John Middleton. From the point of view of my family and me, the price of their sham good name was far too high. The unfortunate fact is, the almost certainty is that many thousands of other individuals and families have similarly suffered over the years. The further certainty is that many more will suffer until cultural change is forced upon the court and the justice system. In 2009, I told that court that truth and fact are far more powerful than any judgment of their sham court. This video is one step in demonstrating that fact. Okay, after that little introduction, back to the task at hand, exposing the corruption. By carefully demonstrating and exposing judicial and other justice system corruption, I am going to force the removal from office and incarceration of a number of Victorian judges and lawyers named in this video, and I will force cultural change in the so-called justice system of Victoria and probably all of Australia. Coincidentally, I also demonstrate that corrupt corporations such as banks and city councils literally use the corrupt courts and corrupt lawyers as tools to commit and conceal their own fraud and corruption. As you would be aware, all courts and judges and barristers derive their reputation and social status from the generally accepted but in fact preposterous notion that all judges and barristers are paragons of virtue, and the courts are conducted openly and honestly, and the judges are impartial, and that the appeals system identifies and corrects any errors made in the lower courts. In this video, I demonstrate that the so-called justice system of Victoria is fatally infected with a fundamental and cultural flaw which ensures that the justice system is in fact on a self-perpetuating carousel of crime, corruption and concealment. That fundamental, systemic and cultural flaw is that in order to maintain the reputation of the courts and themselves, the judges and the opposing barristers will not stand up and point out the fact known to them that a barrister and solicitor have brought a manifestly fabricated claim or defence to court. They will instead conceal it by complicit silence and or by publishing reasons for judgment which conceal what is in fact criminal conduct. Now, because they are assured that the judges and opposing barristers will not expose them, corrupt barristers and solicitors habitually bring fabricated claims and defences to court. Now here I carefully make the distinction between a manifestly fabricated claim or defence and a legitimate but hopeless claim or defence. A legitimate but hopeless claim or defence is one where honest but misguided people genuinely think that they have a good claim or defence, while the fact is that their claim or defence is manifestly hopeless. Barristers and solicitors who knowingly or carelessly act for such misguided people are in fact scamming that honest but misguided client. Of late, but rarely, on the application of the opposing barristers, the courts have ordered barristers and solicitors to bear the costs if they have acted in such a legitimate but hopeless claim or defence. On the other hand, a manifestly fabricated claim or defence is one which manifestly flies in the face of the facts and or the law, and which would pervert the course of justice if successful. It is this type or class of corrupt conduct which, to a man and woman, the judges and barristers of Victoria will and do deny and conceal. So because they are assured of protection, Victorian barristers and solicitors will and do bring such fabricated claims and defences. They do so for their own self-enrichment or on purported behalf of a corrupt client, such as those named in this video. Either way, they are enriched. Happily, for the complicitly silent opposing barristers, they are also enriched. This video demonstrates all classes of the corrupt conduct which I have just described. So, my viewers, those of you who have been unfortunate enough to have been involved in civil court proceedings in a Victorian court, the possibility, if not probability, is that you have been defrauded by the systemic and cultural flaws of the court. The corrupt conduct exposed in this video occurred over a period now in excess of 32 years. The corrupt culture exposed in this video is systemic, embedded and ingrained. I am going to excise it. I will see at least the 3 Victorian judges who are on the screen now removed from office and incarcerated. Those judges are Justice Robert Osborne, Major General Justice Greg Gard, and Federal Court Judge Justice John Middleton. A number of barristers and solicitors named in this video will rightfully suffer a similar fate. This video may be a little long, however, the subject demands particularity. Now, in this video I only deal with things which are well and truly documented and which may be readily verified. In other words, I present material which the courts and its denizens cannot deny. While the judges of the Supreme Court speak with the authority of the court, I trump them by speaking with the authority of fact and truth. In this early part of the video, I will first show a number of seemingly disparate and serious corrupt things. However, I will link them together with the narrative which follows. Now firstly, and as an example of the extreme lengths that the Victorian judges and barristers and the court per se will go to conceal their corrupt conduct, is graphically demonstrated by the fraudulently fabricated, authenticated order document which is on the screen now. Now, for my viewers who have been fortunate enough to avoid the supposed justice system so far, an authenticated order document is a document issued under the seal of the Victorian Supreme Court and which authoritatively attests to the fact of and sets out an order of the court. Such documents are probably the most powerful and authoritative documents in a democracy supposedly governed by rule of law. Now, in this case, I had filed Court of Appeal documents which alleged and particularised the overt corrupt conduct of Justice Robert Osborne and a number of barristers and solicitors, including the now Major General Justice Greg Gard and the by then Federal Court Judge Justice John Middleton. After I filed my appeal, the court fabricated the purported authenticated order document which is shown on the screen now. And then, knowing full well that it had been fabricated, the court and some of the barristers and solicitors named by me served it on me, and relying on it, they represented that my appeal had been filed too late and was therefore invalidly filed and would not be heard by the Court of Appeal. That document fraudulently represents that the Order 1 set out on that document had been made on 29th of November 2006, whereas the fact known to the court and the authors and utterers of that document was that no such order had been made on that date or at all. At that time, because of the inherently corrupt culture of the justice system which protects itself, a number of barristers had refused to act for me to put my allegations. So I was a layperson representing myself. On the face of it, the court and the authors and utterers of that document thought that they could dupe a simple layperson such as myself. They were unsuccessful in that regard, and after that document was served on me, I contacted the Pathonetry's office in an effort to find out the author's identity and the process by which it was prepared. They refused to tell me, and instead asked that I return it and destroy all copies, supposedly because the court could not have erroneous, authenticated orders in circulation. I then became barraged with a series of phone calls demanding that I return it and destroy all copies. I refused, of course. In this instance, the great probability is that Justice Robert Osborne directly conspired with at least the now Major General Justice Greg Gard and with several officers of the court to fabricate it. On the other hand, it may well have been issued with the authority of Warren and or Maxwell. I did successfully overturn that fabricated document and order and did get into court. When faced with my allegation that no such order was ever made, the court made further orders which were contrived to give that supposed order and document the appearance of mistake. They were fabricated in the face of the court rules. I will describe that series of fabrications later in this video. Subsequently, 6 Victorian Court of Appeal judges denied and concealed the palpable fact known to them that that document was fabricated. As I will demonstrate later, they also fabricated further orders and published fabricated reasons which were contrived to conceal the corruption alleged and evinced by me. I think that the fabrication and uttering of that document is probably one of the highest crimes ever committed in Australia. So take a good look at that document. It is probably the only such fraudulently fabricated, authenticated order document ever produced by a superior court in a so-called democracy supposedly governed by rule of law. In this video, I provide the most complete particulars of justice system and other corruption ever assembled. I will provide full particulars of those fraudulently fabricated, authenticated order documents later in this video. Now, just to add a little spice at this time, as I will shortly demonstrate, some years ago an ANZ Bank subsidiary was involved in a most serious property fraud which had been described in the Victorian Parliament. That was a conspiracy against me and involved many others and many millions of dollars. Now, as I will shortly demonstrate, that ANZ subsidiary conspired with its solicitor, John Norman Price of Gare and Bra, and others, to conceal that conspiracy and to pervert the course of justice. In turn, John Norman Price engaged the then junior barrister, who is the now Major General Justice Greg Gard, for that overtly criminal purpose. At that time, the then Lieutenant Colonel Greg Gard was well known for being loose with the truth, or as one contemporary barrister quaintly put it, known to gild the lily. At that time, not knowing or caring which judges may hear his fabrications, or which barrister may oppose him, Gard prepared a purposely fabricated written submission. Contextually significant, at that time, the present Royal Commissioner into Banking, Kenneth Hayne, was a Victorian barrister, and Gard knew well that I could retain Hayne or any other Victorian barrister to oppose him. On that occasion, Price and Gard and the ANZ subsidiary did successfully pervert the course of justice. Gard then appeared as barrister in several further proceedings which flowed directly from the fact that he had perverted the course of justice, and each of those proceedings he had to necessarily continue to pervert the course of justice. Then in 2006, before Justice Robert Osborne, I alleged and explicitly and unequivocally evinced Gard's criminal conduct. Osborne then published reasons for judgment which concealed Gard's criminal conduct by repeating Gard's initial fraudulent misrepresentations and representing them to be fact. Osborne fabricated those purported reasons, knowing full well that they could come before any Victorian Court of Appeal judge, including Maxwell or Warren. Subsequently, 6 Victorian Court of Appeal judges made orders and published reasons for judgment which were contrived to conceal Osborne's criminal conduct and coincidentally conceal Gard's serial corrupt and criminal conduct. At that time, the now High Court judge, Geoffrey Nettle, was a Victorian Court of Appeal judge. At the present time, the directors and executive of the ANZ Bank, including the doyen of Australian society, David Gonski AC, are engaged in concealing the serious criminal conduct which they have unequivocal evidence of, namely that Justice Robert Osborne published reasons for judgment which were contrived to conceal that an ANZ subsidiary sold land in the circumstances of the conspiracy which the now Major General Justice Greg Gard concealed by perverting the course of justice. Further, the fact that the ANZ directors and executive are engaged in concealing that criminal conduct is set out in a submission to the Banking Royal Commission. I am not holding my breath on that one. Now, of great significance is the palpable fact that at the time that Major General Justice Greg Gard was appointed a Supreme Court Judge and President of the Victorian Civil and Administrative Appeals Tribunal, numerous Victorian judges, barristers and solicitors were well aware that he was a serial fraudster and not a fit and proper person to be a lawyer or person in charge of a lolly shop, let alone a judge of the Supreme Court of Victoria. The question is not whether a guard is a fraudster. The question is how many people has he defrauded over the past 30-something years, perhaps even while repaying favours since he became a judge. Now, Gard reaches the mandatory age of retirement on the 1st of April this year, 2019. As a salutary example to other judges and lawyers of his ilk, it is important that proceedings against him are commenced before that date. Once again, I won't hold my breath, but the surety is that I will eventually succeed in having proceedings brought against him, and I will see him and others incarcerated. Those of his ilk are the highest criminals in the land. Now, to the far left of the row of judges on screen is Justice Lex Lasry. In 2005, he was probably the top barrister in Victoria, if not all of Australia. Now, in 2005, he was barrister acting for me in a most serious case of property fraud and conspiracy against me and involving many millions of dollars. Aspects of that conspiracy had been described in the Victorian Parliament. The broader aspects of that property fraud and conspiracy involved at least one officer of the Victorian Land Titles Office, Macedon Ranger Shire Council, Colaban Water, Westpac Bank, subsidiaries of ANZ Bank, solicitors for the ANZ subsidiary, Gerambra, solicitors for the Council and Water Authority, Palmer, Stevens and Rennick, the now Major General Justice Greg Gard, and finally the crooked property developer Kenneth Raymond Buchanan. Also on the lower right of the screen now, alongside the photograph of Buchanan, is a rerun of the ABC television program The Investigators. It is discussing that the Buchanan Timeshare Company, Club Resorts Limited, was defrauding thousands of generally lower socio-economic Australians. I am running it without sound, but you may glean some substance from it. Significantly, the ANZ investment arm, ANZ Nominees, was the fourth largest shareholder in that overtly fraudulent company. That ABC television program arose substantially because of the work done by me to expose the serious corporate corruption which was occurring at that time and for some time previous. Because of the work done by me, the South Australian government flew me and my documents to Adelaide, and then, at least in part due to my work, the South Australian judge, Michael Noblet, refused to give Buchanan's company a credit provider's licence. Prior to that, entirely due to my work, the Victorian Credit Licensing Authority removed Buchanan as a director of the finance arm of his companies, but left the finance company to continue with its corrupt conduct. In addition, at those times, I personally exposed and put an end to a fraudulent prospectus which was contrived to and distributed in such a manner as to attract and dupe and scam the mum and dad investors of Australia. Due to my efforts, that particular prospectus had a probable world record low subscription of about 2.5%. I had made many very serious and powerful enemies at that time, and the surety is that this video will invoke the enmity of all of the most powerful people in Victoria and probably all of Australia. Okay, now I will begin to go to some sordid particulars. On the screen now is the Federal Court Judge, Justice John Middleton. Middleton was appointed a judge in 2006. Prior to that, he was an overtly corrupt Victorian barrister. Now, as I will show, the standalone facts of Middleton's corrupt conduct are sufficiently damning. However, I acquired an unexpected bonus in that regard. That bonus is as follows. In 2006, and while still a barrister, Middleton and his then instructing solicitors communicated in writing and set out certain particulars which partly evince Middleton's corrupt conduct and expressly evinces that his opposing barristers were well aware of his corrupt conduct. Then, in 2009, when Middleton was a federal court judge, I published particulars of his corrupt conduct and of Gard and Osborne and the Court of Appeal judges and others on my website courtsontrial.com. That prompted further written communication between Middleton and his earlier instructing solicitors. Middleton's side of that further communication occurred on federal court letterhead and referred to the allegations on my website and included a copy of the earlier written communication. In circumstances which I will discuss later, I acquired a copy of that further communication on federal court letterhead and the attached earlier communication. So the bonus is that evidence of Middleton's corrupt conduct is part set out on federal court letterhead, signed by him. The further bonus is that I can demonstrate that his opposing barristers were aware of the corrupt conduct which Osborne and the Court of Appeal judges deny and conceal. As an added bonus, from the transcript of proceedings, I can demonstrate that the presiding judge was aware that Middleton was deceiving the court at the time that his deception was occurring. In other words, I can show the trifecta. I can show Middleton's knowledge of his own corrupt conduct. I can show that his opposing barristers knew he was acting corruptly, and I can show that the presiding judge knew that he was acting corruptly. Now, the circumstances leading to Middleton's corrupt conduct were as follows. Now, as I said earlier, in 2005, the now Justice Lex Lazary was probably Victoria's top barrister, and he was my barrister, and he prepared and settled my statement of claim, where I was suing the Macedon Ranges Shire Council and Colaban Water to recover my losses, which were caused by the conspiracy which had been described in the Victorian Parliament. Unfortunately for me, as my claim was coming due for hearing, Lex was called overseas to act for an Australian who was about to be executed in Singapore. So, my then solicitors retained John Middleton, who was probably Victoria's second highest barrister, and he certainly charged accordingly. Then, unbeknown to me, Middleton made several rather simple comprehension errors of simple written English, so that he completely misunderstood my case. Now, on the screen now is a series of very fraudulent and unlawful plans of subdivision. I will explain their full significance shortly. Middleton's first simple comprehension error was as follows. In my affidavit, I set out that in several earlier court cases, the council gave sworn evidence that it had processed those plans as parts of a single subdivision. That was sworn evidence as to the state of mind of the council when it sealed the plans. Then my affidavit said that in 2000 I had learned that the council had in fact processed those several separate plans of subdivision as several separate subdivisions. That statement was a clear and accurate statement by me as to my knowledge of the true state of mind of the council while processing the plans. It was not and could not be construed to be a statement by me as to my mind as to the status of the plans of subdivision. Unbeknown to me, Middleton misunderstood that simple statement to be a statement as to my state of mind of the status of the plans of subdivision. Middleton's careless and preposterous misunderstanding was that in 2000 I had learned for the first time that the several plans of subdivision represented several subdivisions. Middleton's second simple comprehension error was aggravated because it included a serious error of law. On the screen now, my affidavit said that the council had sealed the plans in direct contravention of its statutory duty to refuse to seal them. The very next paragraph of my affidavit said that the council had unlawfully sealed the plans. Now, on a proper reading of those two paragraphs of concise writing, the unlawful act in the second paragraph was not the sealing per se, but was that the council had acted in direct contravention of the law which compelled it to refuse to seal them. Middleton's second simple misunderstanding was to read those two paragraphs, as separate, discrete, unlawful things. Firstly, that the council had acted in breach of its statutory duty, and secondly, that the sealing per se was unlawful. Now, in order that you may understand the gross nature of Middleton's misunderstanding, on the screen now is section 569B10 of the then Local Government Act, and as you can see, that section provides that the sealing of a plan of subdivision was conclusive evidence for all purposes that there had been compliance with the Act with respect to such sealing. Now, in simple terms, that meant that there was no such thing as unlawful sealing per se. So, to understand my assertion as to the council acting in breach of its duty to refuse to seal, and my assertion as to unlawful sealing, I will draw an analogy. Assume for a moment that a person has a restraining order which prevents him from crossing to the northern side of a road, and then that person goes to a pedestrian crossing and lawfully crosses the road with the green walk light. Then that person has manifestly unlawfully crossed the road in breach of the restraining order, but the crossing of the road per se with the green light was quite lawful. Now, in the circumstances of the sealing of the plans were essentially identical. There was restraining legislation which restrained the council from sealing the plans, while section 569B10 was a permanent green light to the sealing per se. So my assertion as to unlawful sealing could only have one meaning. The unlawful act was the breach of the restraining legislation, and in exactly the same sense, the unlawful act of the person crossing the road was a breach of the restraining order, and not the crossing per se. Now, the difference between the proper understanding and Middleton's two misunderstandings is profound. Firstly, my proceeding related to events which had occurred 25 years earlier, and I necessarily had to rely upon the fact that my claim had been fraudulently concealed until discovered by me in 2000. Now, the fact that each of those plans of subdivision represented a separate subdivision was manifestly not concealed and not concealable. So Middleton knew well that any case put by him, founded on an assertion by him that that fact was concealed from me, was hopeless and could not succeed. Secondly, because Section 569B10 of the Local Government Act was a permanent green light to the sealing per se, then any case put by Middleton that the sealing per se was unlawful was simply preposterous and in the face of the exceedingly simple law. So, as I will demonstrate a little later, Middleton concealed his misunderstandings from me and brought a fraudulently fabricated case which was founded on his gross errors and was in the face of the facts and the law known to him. Now, for complete understanding and to show further serious instances of court corruption, I will show the significance of those plans and exactly how corrupt barristers and solicitors conspired with the council to serially bring fraudulent court cases and conceal the corrupt conduct of the council. Now, back at the relevant time, the Victorian Sale of Land Act prevented the sale of allotments on subdivisions consisting of 3 or more allotments until such time as the Registrar of Titles had approved the plans, and in turn the Local Government Act prevented the Registrar from approving plans until such time as all required infrastructure such as roads and water were complete. So, in other words, a developer could not sell land on subdivisions of 3 or more allotments until the roads and water supply, etc. were completed. So, in order to avoid the law, the solicitors Palmer, Stevens and Rennick and the executive of the council and water authority and the fraudster Buchanan came up with a scheme to have the council and the titles office process a series of unlawful 2-lot plans of subdivision. 3 such plans are on the screen now. Now, on the leftmost plan you can see an area which I have outlined in red and marked, and it is marked as Lot 1. That represents a genuine intended allotment. And the area outlined in blue is a sham or scam allotment which is marked as Lot E. Now, on the centre plan, the area which was Lot 1 on the first plan is marked NIS for not in subdivision. The genuine allotment outlined in red on the second plan is part of the sham or scam allotment on the first plan, and the new scam or sham allotment on the second plan is marked as Lot F. Now, that scam or sham sequence is then continued into the third plan, which is on screen. Now, that scam or sham sequence is then continued in a further several plans in the series until 18 genuine allotments are set out and created. Now, this little scheme operated in the following manner. Firstly, Buchanan filed a legitimate notice of intention to subdivide together with a lawful and legitimate plan showing all intended allotments with the council. The Shire engineer, Graham Noel Wilson, then submitted that legitimate plan to the council, and the council approved that legitimate plan and resolved to require the developer to complete all necessary roads, etc. In this case, the council considered the legitimate plan on 20th of February 1980. The Shire engineer then destroyed the legitimate notice of intention and the legitimate plan and did not serve a notice requiring the developer, Buchanan, to construct the roads. Buchanan then filed a series of sham notices of intention to subdivide, and each notice was accompanied by one of the series of sham and scam two-lot plans of subdivision. The Shire engineer then treated each of those sham notices of intention and sham plans as separate subdivisions. The Shire engineer then separately referred each of those separate sham plans of subdivision to the various statutory authorities which he was required to refer them to. Then, on 21st of May 1980, the Shire engineer fraudulently represented to the council that the original plan had been submitted in 7 parts, and he recommended that the council seal each of those 7 plans. A copy of the engineer's report of 21st of May 1980 to that effect is on the screen now. The ignorant shopkeeper, farmer and teacher councillors then dutifully accepted the engineer's report, and they resolved to seal each of the sham and scam plans. Then each sham and scam plan was separately filed with the Victorian Land Titles Office. The Titles Office then separately approved each of the sham and scam plans on the 28th of November 1980. The Shire engineers and the processing officer in the Titles Office were each well aware that the plans were in breach of the sections of the Local Government Act and of the Transfer of Land Act, which required a plan of subdivision to show all allotments and roads intended to be set out. And in this case, they were not. That little sequence ended up with a series of approved subdivisions without planning permits and without roads or water, and where the council had not resolved to require Buchanan to construct the roads or waterworks. Then, in December 1980, I purchased a number of those allotments. That purchase was financed by Westpac Bank and by Palmer Stevenson Rennick. At that time, I was led to believe, and did believe, that at law Buchanan was required to construct the roads and waterworks. Palmer Stevenson Rennick acted for me and for the vendor Buchanan in that transaction. The Westpac branch manager in that transaction, John Saviour Muscat, personally valued the blocks, and he subsequently became a director of one of the Buchanan companies which were conducting serious fraud against the generally lower socio-economic people of Australia, and against me for that matter. Then, in April 1982, I discovered small aspects of the broader conspiracy. Those aspects included that a Westpac subsidiary and Palmer Stevenson Rennick and Buchanan were double dealing in land which had been sold to me, and that the Westpac subsidiary was double financing that double dealing to separate purchases. At that time, I informed them that I would refer the matter to the police. For the next several weeks, armed men visited my home at night and pointed rifles at me and my then wife and young children, and then quickly ran off. I got the message, but refused to be intimidated, and did report the matter to the police. Unfortunately, the police said it was a civil matter and refused to investigate. Then, immediately afterwards, the Shire's engineer and the Shire secretary fraudulently represented that because I had purchased the blocks, I was liable for the road construction costs. Now, because I was an ignorant service station proprietor, I believed the authoritative representations of the council and the water authority. By that time, I knew Buchanan to be crooked, and I thought I had been duped by him, and I dutifully paid up about $400,000 in today's money to the council and water authority. As I now know, that was a ploy by Palmer, Stevens and Rennick and the council and water authority executive to place financial stress on me and to hopefully cause my default on the Westpac subsidiary loan, and thereby effectively undo and conceal the double dealing and double financing. To that end, yet another crooked solicitor wrote to the Westpac subsidiary effectively demanding that they enforce the loan with me, while knowing full well that the double dealing and double financing was occurring. Unfortunately for them, I was a little more financially stable than my second-hand car and simple lifestyle indicated. They were unsuccessful, but I was placed under stress. The council and water authority then constructed the roads and waterworks, but at more cost than that which I had paid them. The council then billed me for the overrun of costs. At that time, I purchased a copy of the Local Government Act and learned that the council's claim against me was fraudulent, and I refused to pay. At that time, I had no idea of the series of scam and sham subdivisions, but in the case of lawful subdivisions, it was the subdivider who had been served with a notice requiring him to construct the roads who was liable, and that liability could not pass to me as purchaser of new allotments. The council was locked in. It had a fraudulent claim, for a fraudulent debt in my name in its books. The council then secured the services of a dime a dozen crooked solicitors and a barrister, Mr. B. Phillips, and issued fraudulent magistrate court proceedings against me. To make good that fraudulent magistrates court claim, the council had to necessarily commit several acts of perjury and one act of overt misrepresentation of fact and law. The first act of perjury was to conceal from the court that the Shire engineer had destroyed the legitimate plan of subdivision and had not served the notice of requirement which the council had resolved to serve in respect of the roads shown on that plan. The further act of perjury was to conceal from the court that the council had not processed the legitimate plan any further, but had instead processed the scam and sham plans as separate subdivisions, and without having resolved to impose a requirement that Buchanan construct the roads shown on any one of those plans. Then, once having deceived the court with the necessary perjury, the council would then need to misrepresent fact and law to deceive the court into a belief that the in fact non-existent requirement that Buchanan construct the roads flowed to me as purchaser of new allotments. At that time, I was completely unaware of the scam and sham plans, and unaware of the necessary perjury, and unaware of the misrepresentations as to fact and law that they intended to make. I was, however, aware of the law as it related to lawful subdivisions, and at law the council's claim against me was hopeless. The council refused to comply with notice that it provide me with copies of its documentary evidence. The council then refused to comply with Supreme Court orders that it provide me with that documentary evidence. At that time I was not concerned because the law was clear. It was the owner of the parent property who was liable for the road construction costs, and I was not and could not be construed to be their person. At that time I applied for and was granted legal aid to defend the claim. Both the Legal Aid Commission and my solicitor and barrister, Mr. Barry Fox, were well aware that the council and its lawyers were bringing a fraudulent claim without any possible basis at law. When the matter was called, the council's barrister handed my barrister a bundle of documents. That bundle of documents included a copy of what I now know to be a locality plan. That in fact locality plan is on the screen now. Now each of what I now know to be the scam and sham two-lot plans was also in the bundle, as was the council minutes where the council had considered the legitimate plan and the engineer's report, which I showed before, where Wilson represented to the councillors that the series of plans was a legitimate plan submitted in parts. With reference to those documents, the Shire engineer, Graham Wilson, then gave sworn evidence. His sworn evidence included that the plan, which is on the screen now, was the plan of subdivision which had been considered by the council on 20th of February 1980, and that the council had resolved to require the roads shown on that plan to be constructed. Wilson then swore that on the 20th of February he had served Buchanan with a notice requiring him to construct the roads shown on the in fact locality plan. Wilson then referred to the scheme plans and gave evidence that the plan considered by the council on 20th of February 1980 had been processed in several parts. By the in fact perjurious representations that the plan considered by the council had been processed in several parts, the Shire engineer led the court to believe that the legitimate plan remained on file and that the resolution of the council in respect of that legitimate plan flowed to and was valid in respect of the in fact scam and sham plans actually processed by the council. Then, having deceived the court in that regard, and knowing full well that he was lying, the councillor's barrister represented that I had purchased the land in December 1980 and was liable for the road making costs. In my defence, I summoned the other people who had also purchased allotments in 1980, and they gave evidence that they had not been called upon to pay any portion of the costs. With unimaginable stupidity, with the other owners of allotments of identical status as myself standing before him, the magistrate held that I had purchased the land in 1980 and was the owner liable for the road construction costs. The magistrate then ordered that I pay the overrun of costs. I have great difficulty believing that the magistrate believed himself. I again applied for legal aid to appeal to the Supreme Court. That legal aid was also granted. The appeal came on before Justice William Kay of the Supreme Court. On affidavit, Wilson repeated the evidence given to the magistrate. The bundle of documents was exhibited to Justice Kay. Justice Kay published his written reasons on the 11th of July 1988. At page 2 of his reasons, Justice Kay said that on 12th of February 1980, Buchanan lodged several plans of subdivision together with a single notice of intention to subdivide. Justice Kay then said that on the 20th February 1980, the Council gave Mr Buchanan notice of requirement to construct the roads. Justice Kay then said that on 21st of May 1980, the Council resolved to seal the plans. Justice Kay then said that the magistrate held that I had purchased the land in December 1980 and sold it in 1983, and that I was the owner of the land within the meaning of the Local Government Act. Justice Kay then said there was no evidence before the magistrate that at the time of service of the notice of requirement, or at any relevant time thereafter, that I was possessed of any equitable interest in the land. He then said that I was not the owner from whom the Council was entitled to recover any payment for construction of the roads. Justice Kay then set aside the magistrate's orders. After publishing his reasons, Justice Kay said that this matter should never have come to court, and that if he could, he would order that the Council's lawyers not get paid. Now, in that little sequence, the Legal Aid Commission was twice aware that the Council and its lawyers had knowingly brought a fraudulent proceeding, and my solicitors and barristers in both hearings were also well aware. And then Justice Kay was also well aware, but no one had the courage or the integrity to say so. Justice Kay's benign assertion that there was no evidence before the magistrate in fact conceals that the explicit and unequivocal evidence before the magistrate was that I was not and could not be construed to be the owner of the property which had been cancelled and ceased to exist on the 28th of November 1980. So, how many others did the Council solicitors and barristers then go on to defraud in the silently complicit courts? At that time, neither the Legal Aid Commission or myself or my lawyers or Justice Kay even suspected the nature of the sham and scam plans, but the Council's solicitors and barrister sure as hell knew, and that is why they refused discovery, including refused to comply with Supreme Court orders compelling discovery. And then they handed my barrister the bundle of documents after the matter was called. I then instituted county court proceedings against the Council and Water Authority to recover the monies paid to them. My claim included a claim for damages. At that time, because I could not show any wrongdoing, my claim was for recovery of monies paid and had been received by mistake of law. My claim included a claim for damages. The Council's solicitors at that time were a firm called Maddock, Loney and Chisholm, now known as Maddox. They were the experts in local government law and had many councils as clients. They were also a bunch of serial crooks, and remain so to the present day. As I will show later, they also conspired with Guard when he perverted the course of justice, as discussed earlier. They also conspired to deceive the then Minister for Water when the ministerial inquiry followed the conspiracy being raised in Parliament. In addition, as I will shortly show, they, and in particular their now CEO, Michelle Elizabeth Dixon, conspired with Gard and numerous other lawyers and with Osborne to conceal their own and Gard's corruption. They also, and in particular Michelle Elizabeth Dixon again, conspired in the Victorian Court of Appeal to conceal their own, Gard's and Osborne's criminal conduct. They were and remain a bunch of crooks, and they were party to the council bringing fraudulently fabricated documents and defences in the proceeding which I am now discussing. In their defences and in their discovered documents, the solicitors for the council, now Maddox, and the council fraudulently and perjuriously made the identical misrepresentations as had been made before the magistrate and Justice Kay. In particular, during that proceeding, Maddox and the council prepared a document entitled Consolidated List of Documents, and the header of that document is on the screen now. Now, document 13-13 in that consolidated list of exhibited documents was said to be a copy plan of subdivision sealed the 21st of May 1980, and then LP for lodge plans, followed by a series of lodged plan numbers. Those lodged plan numbers being the numbers allocated by the Land Titles Office in respect of each of the scam and sham plans and a couple of other scam and sham plans not in present discussion. Now, the specific so-called plan of subdivision exhibited to item 13-13 of that consolidated list is on the screen now. And as you can see, it is the identical, in fact, locality plan as was perjuriously exhibited in the Magistrates' Court and in the Supreme Court before Justice William Kay. You will observe that at the top of that in fact locality plan is the numbers 13-13. Those numbers were written on the top of that in fact locality plan by solicitors Maddox, Loney and Chisholm, now Maddox. Also exhibited to that item 13-13 were copies of each of the scam and sham plans, and each of them bore the same handwritten numbers, 13-13. That was a specific, unequivocal reiteration of the perjurious evidence given before the magistrate and Justice Kay, excepting on this occasion that perjurious evidence was jointly made and uttered by Maddox and by the council, and was intended to and did convey the fraudulent representation that the mind of the council was that it had processed the legitimate plan of subdivision in several parts and not as separate subdivisions. After exhibiting those in fact fabricated documentary evidence to me, that proceeding then came on for hearing. On the first day of hearing, the Council and Water Authority offered return of my money in full settlement. At that time, I was advised that I should accept that offer because the court would be unlikely to award damages in respect of mistake of law, and if I refused the offer and then failed in the damages aspect, I would be liable for costs from the time of the offer. I accepted that offer. During the course of that proceeding, I discovered the true nature of the sham and scam plans. However, I also discovered that Buchanan and Palmer, Stevenson and Rennick were seriously mistaken and were serious drongos. The fact was that the scam and sham plans did not and could not facilitate avoidance of the Sale of Land Act. On a proper reading, the Sale of Land Act related to a developer's intention, and not to the actual plans in fact lodged. And as Buchanan's intention was an 18-lot subdivision, his sham and scam 2-lot plans did not and could not facilitate avoidance of the Sale of Land Act. At that time, I prepared a brief for my then barrister. Page 3 of that brief included a pasted copy of Section 9 of the Sale of Land Act, and I had underlined several critical words which Palmer, Stevenson, Rennick and Buchanan had overlooked or not appreciated. A copy of that part of page 3 of my brief is on the screen, and the critical words in Section 9 were underlined. I will come back to them shortly. Then page 5 of my brief contained copies of a couple of the scam and sham plans, and above them I had handwritten some notes, and a close-up of those notes is on the screen now. Those notes said, notwithstanding that it was illegal, Buchanan had sold at least 2 of the allotments, and I had an arrow pointing to the notices of disposition which were on page 4. Then below that I said to the effect, in order to avoid the provisions of Section 9 of the Sale of Land Act, Buchanan lodged 7 separate plans which were contrived to create several subdivisions of 2 lots each. Then at page 8 of my brief I included a pasted copy of Section 5691 of the then Local Government Act. That section was quite explicit and required a developer to give notice of his intention, and in this case Buchanan's clear intention was a single 18-lot subdivision. So now, going back to my underlining of part of Section 9, which is on the screen again now, it can be seen that Section 9 operates where a developer is required to give notice, and in this case, notwithstanding that Buchanan had given a series of fraudulent notices of intention, he was and remained required to give notice of his intention to do an 18-lot subdivision, and therefore he remained fair and square trapped by the well-drafted legislation, and he had not avoided Section 9 at all. So, at the time of the County Court proceeding, I could not say or allege that the Council had aided and abetted Buchanan's fatally flawed scheme to avoid Section 9. At that time I had no option other than to accept the Council's assertion that its mind was that it had processed the legitimate plan in several parts, and that the Council's resolution to require Buchanan to construct the roads flowed to and affected those several scam and sham plans. On settlement of that County Court proceeding, a release was signed. That proceeding was settled in 1991. At that time, I knew in my mind that the Council had aided and abetted Buchanan, but I had no hard evidence. Then a few years went by, and in 1995 I issued Supreme Court proceedings against the Council and Water Authority, and personally against the Shire Engineer and the Joint Shire and Water Authority Secretary. That 1995 Supreme Court proceeding was related to quite separate properties which were subject to the broader conspiracy, and was entirely unrelated to the earlier County Court proceedings, and unrelated to the properties subject of the scam and sham plans. Of present relevance is that during that proceeding I allowed the solicitor for the Water Authority into my home to take copies of any documents which were relevant to that 1995 Supreme Court proceeding. At that time, unbeknown to me, and without my permission, he also took a copy of the earlier brief which set out that the Scam and Sham plans did not facilitate avoidance of the Sale of Land Act. Nothing else of that 1995 Supreme Court proceeding is presently relevant. Then, in 2000, I finally discovered the evidence that the mind of the council was that it purposefully processed the several Scam and Sham plans as separate subdivisions, and that it had falsified the evidence before the magistrate and before Justice Kay by clipping the surveyor's identifying numbers from each of the Scam and Sham plans. They had also falsified the evidence in the earlier County Court proceeding, and the settlement in that proceeding was obtained in fraud. I will further particularise a little later. So, as you can see, the Shire engineer duped the councillors into sealing an illegal series of separate subdivisions by representing that the several Scam and Sham plans represented parts of the single subdivision which had a planning permit and which they had approved. The fact, however, known to the Shire engineer and the Shire secretary and the council solicitors Palmer, Stevens and Rennick and Buchanan, was that those plans created several subdivisions without planning permits and which had not been approved by the council, and the council had not resolved to require Buchanan to construct the roads shown on any of those Scam and Sham plans. Now, as discussed earlier, the Shire engineer destroyed the legitimate plan and did not serve the notice requiring Buchanan to construct the roads and waterworks shown on the legitimate plan. At the time that Buchanan filed the Sham and Scam plans, the Shire engineer and Shire secretary fabricated separate notices of requirement that Buchanan construct the roads shown on each of the Sham and Scam plans, and they predated those fabricated notices to make them appear to be issued pursuant to the council's resolution to serve such notice in respect of the legitimate plan which they had destroyed. Each such fabricated notice referred to the unique surveyor's plan reference number at the foot of each of those Scam and Sham plans. Each such fabricated notice also fraudulently represented that it refers to a plan which was filed on the 12th of February 1980, whereas only the legitimate plan was filed on that date. The Scam and Sham plans were in fact filed on 4th of March 1980. So when it came to suing me for the overrun of costs, the council did not have the legitimate plan and did not have a copy of a legitimate notice of requirement relating to the legitimate plan. So, for the purpose of deceiving the several earlier courts, the Shire engineer exhibited the single notice of requirement which is on the screen now. And as you can see, that notice refers to a particular plan by its unique plan number. And in this instance, that number is 79305/G and is in fact a surveyor's reference number set out at the foot of one of the Scam and Sham plans. So, for the purpose of perverting the course of justice and concealing his crimes, the Shire engineer copied each of the Scam and Sham plans in such a manner as to omit or remove the unique surveyor's reference number from each of the scam and sham plans. He then committed perjury by representing that the locality plan, which is on the screen again now, was the legitimate plan considered by the council, and he fraudulently represented that the purposely fabricated notice of requirement related to that plan. By copying the scam and sham plans in such a manner as to omit the surveyor's reference number, he concealed from the court that the notice was in fact fabricated and in fact related to one of the scam and sham plans which did not show all of the roads. He also concealed that he had purported to serve fabricated notices in respect of each of the scam and sham plans. The council and its solicitors and barrister deceived the Magistrates Court, Justice William Kay, and the County Court in identical manner. In 2000, I discovered that the omitted and concealed surveyor's number could be gleaned from the plans, and to demonstrate, the three plans are on the screen again. The surveyor's reference number is alphanumeric, and the alpha portion is consistent with the sham and scam allotment identifier, and in this case the notice of requirement exhibited by the council in all three courts was numbered 79305/G, and that is a reference to the rightmost plan on the screen, where the sham and scam allotment is marked as Lot G, and that plan only has a small portion of the road shown on it. It then became immediately obvious that the Shire engineer would not have exhibited that notice of requirement if he had a copy of the legitimate notice. In addition, he could not exhibit the notice relating to the first and second scam and sham plans, which showed all of the roads, because the single legitimate allotments shown on them had been purchased by people other than myself. It logically followed that the council had not served Buchanan with a notice of requirement in respect of the legitimate plans. Then, having regard to the fact that the Shire engineer had exhibited an in fact locality plan in each of the three previous court proceedings and represented that locality plan to be the legitimate plan, it became apparent that the Shire engineer and the Shire secretary had in fact destroyed the legitimate plan and not served the notice of requirement on Buchanan. It then logically followed that the Shire engineer and the Shire secretary had in fact aided and abetted Buchanan's and Palmer Stevens and Rennick in their flawed scheme to sell the land in breach of the provisions of the Sale of Land Act, and had in fact processed each of the plans in the series of scam and sham plans as separate and discrete subdivisions, and not as parts of the legitimate plan as said in evidence in each of the three preceding court cases. It was then apparent that the Shire engineer, Graham Noel Wilson, had concealed his and therefore the council's true mind by perjury and falsification of documents in each of the three earlier court proceedings. The result of all that was the conclusion that the Shire engineer and the Shire secretary, and therefore the council, was well aware that there never was a lawful means of compelling Buchanan or anyone to provide the infrastructure necessary to make the allotments usable. As I will discuss shortly, the law compelled the council to refuse to seal the plans of subdivision having unusable allotments, and the council had in fact sealed the plans in contravention of that law. That discovery by me led me to conclude that the council had enabled Buchanan to avoid the effect as distinct from the provisions of the Sale of Land Act. I will discuss the distinction between effect and provisions shortly. Okay, now I think that the foregoing sufficiently sets out the background to this aspect of my new 2005 Supreme Court proceeding against Macedon Ranges Shire Council and Colaban Water. Now, to draw an analogy. Having discovered that the council had fabricated documents and committed perjury to conceal its true mind in the earlier proceedings, I was free to bring the new proceeding which alleged that the true mind of the council was deliberate murder rather than mistaken manslaughter alleged in the earlier county court proceeding. My new proceeding was to recover the damages which the earlier perjury and fabricated documents had caused me to forego in the previous county court proceeding. The gravamen or cause of action or claim in my new 2005 proceeding was that, while knowing full well that the roads etc. were not present and there was no lawful means of compelling Buchanan or anyone to provide those roads, the council had sealed the plans in contravention of the law which compelled the council to refuse to seal plans of subdivision where the allotments were unusable. And in this case, that new gravamen or cause of action had been fair and square concealed by perjury and falsification of documents in 3 earlier court proceedings. Now, as discussed earlier, Middleton had replaced Lex Lazary as my barrister, and notwithstanding my experience at the hands of corrupt courts and barristers, I had absolute confidence in Middleton. Now, in this case, the barristers and solicitors for the council and for the Water Authority issued summonses seeking summary dismissal of my claim. The several grounds for those applications included that the council had not fraudulently concealed my claim, but had instead openly disclosed my new gravamen or cause of action many years ago, and that my claim was barred by the Limitation of Actions Act, which is commonly referred to as the Statute of Limitations. Now, to fully understand Middleton's corrupt conduct, I am going to relate it as it unfolded to me. The hearing of the summary dismissal applications came on before then Master Eftham on 14th and 15th of November 2005. At the time of the hearings I was unwell and did not follow them, so I ordered a transcript so that I could enjoy the detail of the trouncing given to the Council and Water Authority. Upon reading the transcript, I was shocked and horrified to discover the outrageous fabrications put by Middleton. At that time, I did not understand how such conduct had occurred, but by letter of 14th of February 2006, erroneously dated 2005 by me in the new year, and essentially told him he was a fraudster, and I set out the particulars of his fraud as then understood by me. I copied that letter to his instructing solicitors. It was that letter which prompted the written communications between Middleton and his instructing solicitors, which I discussed earlier in this video. In that letter, I demanded Middleton appear at my inevitable appeal and explain his shortcomings to the court. I also demanded that Middleton refund the $86,000 paid to him. In the face of the facts, Middleton denied my allegations, and he refused to appear at my inevitable appeal, and he refused to refund his fraudulently incurred supposed fees. So now I will show you what Middleton submitted to the court. On the screen now is Middleton's submission at page 45 of the transcript of the second day. In that submission, Middleton said that I thought that the series of scam and sham plans was a single subdivision submitted in sections when in fact it was a whole new series of subdivisions. That submission followed his page 44 submission, where he explained to the court that the scam and sham plans represented a series of subdivisions, and then he said what's on the screen now. Middleton said not to Mr. Thompson's knowledge, however. It took a little while for this to sink in. So, in simple terms, Middleton said that I was a dribbling nincompoop who was too stupid to know that the scam and sham plans represented a series of discrete subdivisions. Now, at the time of making those submissions, Middleton knew well that the fact that the scam and sham plans represented a series of discrete subdivisions was not concealed and could not be concealed, and he also knew that being a dribbling nincompoop did not and could not provide relief from the limitations of Actions Act. In my letter to him, I said what's on the screen now. As you can see, I said that I do not know of anyone so moronic as to think 7 plans equals 1 subdivision, as you submitted of me at pages 44 and 45 of the Day 2 transcript. Now, as you saw earlier, in his reply to me, Middleton denied my allegations as to the foregoing flagrantly fraudulent and corrupt submissions. Middleton is both a fraudulent and corrupt barrister and a fraudulent and dishonest person. Throughout his submissions, Middleton repeated contextually identical variations to the foregoing several times. As I subsequently discovered, those fraudulent submissions arose as a consequence of the first of Middleton's comprehension errors of my simple English affidavit, as I described earlier in this video. I will now demonstrate Middleton's second comprehension error. Now, you may recollect from early discussion in this video that Middleton's second comprehension error was that he misunderstood my affidavit to say that the sealing per se of the scam and sham plans was unlawful. You will also recollect that that comprehension error was in the face of section 569b10 of the Local Government Act, which is back on the screen now, and which provides that the sealing of a plan of subdivision shall be conclusive evidence for all purposes that there has been compliance with the Act with respect to such sealing. Now, nothing can be more clear. At law, there is no such thing as unlawful sealing per se, and no such thing as an unlawful subdivision, and a little common sense discloses that such a provision is essential to the operation of our Torrens title system of property registration. So now, I will show that Middleton's representations in this regard were in the face of my affidavit and the law and plain simple common sense. On the screen now is Middleton's fabrications at page 38 of the transcript. There he says that this is for the first time that it has been alleged that the initial sealing of the plans was unlawful or illegal. Well, as I showed before, that fabrication was in the face of section 569b10 of the law. A little further on, in the same page, Middleton said that I was going back a step, which was never thought of, never even contemplated, that the subdivision itself would be unlawful. Again, in the face of the law. Then at page 40, Middleton said, the point where we are now starting at is the unlawful sealing. And then on the same page, Middleton said to the effect that my new course of action was an attack upon the original plan of subdivision. Now, each and every one of Middleton's fabrications in this regard were manifestly in the face of the law. But even more importantly, as a matter of simple logic, the fact is that the plans of subdivisions simply cannot cause any loss or damage. Lawful or not, they merely set out the dimensions of a parcel of land. The plans per se cannot create a loss-causing deficiency in such blocks of land. Middleton is simply a corrupt fraudster, and he may as well have sung nursery rhymes to the court. Now, a further most serious aspect of Middleton's fraudulent submission is as follows. Now, as discussed earlier, on a proper reading of the law, the scam and sham plans did not and could not facilitate avoidance of the provisions of the Sale of Land Act. However, the effect of, as distinct from the provisions of, the Sale of Land Act could be avoided by the council deceiving the Registrar of Titles. Now, the distinction between the provisions of and the effect of the Sale of Land Act is as follows. Now, the provisions of the Sale of Land Act were quite simple and operated to prevent the sale of allotments until such time as the Registrar had approved the plans of subdivision and issued new titles. Now, the Local Government Act operated to prevent the Registrar of Titles from approving the plans until such time as the required roads, etc. were complete. So, the effect of the Sale of Land Act was to prevent sale of allotments until such time as the roads, etc. were complete. So, a crooked council could facilitate avoidance of the effect of the Sale of Land Act by deceiving the Registrar of Titles into a belief that the required roads, etc. were complete. Now, avoiding the effect of the Sale of Land Act was not a function of scam and sham plans. It was simply a case of the council deceiving the Registrar of Titles in respect of the roads, etc., shown on a legitimate plan or scam and sham plan, as the case may be. And in the instance discussed here, the council did exactly that. While knowing full well that Buchanan had not constructed the roads, etc., the council secretary, Stan Porter, wrote to the Registrar of Titles and said that Buchanan had complied with the council requirement that he construct the roads, etc. A second method of a corrupt council facilitating avoidance of the effect of the Sale of Land Act was to simply seal plans of subdivision without imposing a requirement that the developer construct the necessary roads, etc. And again, the Registrar of Titles would be deceived and would approve plans where the required infrastructure was not present. Macedon Ranges Shire Council employed both methods. The second method was directly employed in respect of the cluster subdivision which is on the screen now. In the case of that subdivision, the Shire engineer deceived the councillors by saying that no requirement was imposed on the subdivider, again Buchanan, because the subdivision was subdivided pursuant to the Victorian Cluster Titles Act. The Shire engineer omitted to tell the councillors that the Cluster Titles Act specifically enlivened the relevant sections of the Local Government Act in respect of cluster subdivisions. As I will discuss later, the ANZ subsidiary discussed earlier and its solicitor John Norman Price and the now Major General Justice Greg Gard conspired with the Council and Water Authority Executive and Ian Loney, whom I will discuss shortly, to pervert the course of justice and conceal the Council's conduct in respect of that particular cluster subdivision. The second method was also indirectly applied to the scam and sham plans in present discussion, because the Council did not resolve to impose a requirement in respect of any one of those scam and sham plans. So the notices of requirement, which were fabricated by Wilson and the Shire Secretary, did not have authority of law. It was that particular aspect which the Council and its various lawyers concealed from the Magistrate and Justice William Kay and the County Court, and they did so by fraudulently representing that the Council had imposed the genuine plan, had processed the genuine plan in several parts, thereby leading the Magistrate and Justice Kay to believe that the resolution of the Council in respect of the legitimate plan flowed to and imposed a requirement on the supposed several parts, being the scam and sham plans. So, as you can see, the Council deceived the Registrar of Titles and did facilitate avoidance of the effect of Section 9 of the Sale of Land Act. Now, paragraph T7 of my statement of claim, which was settled by Lex Lazari and which is on the screen now, clearly and unequivocally set out that the Council had sealed the scam and sham plans in such a manner as to avoid the effect of the Sale of Land Act. That did not and could not be construed to allege that the scam and sham plans facilitated avoidance of the provisions of the Sale of Land Act. Now again, unsuspected by me, the gorilla of a fraudster, John Middleton, made an error of comprehension. He misconstrued the allegation to be an allegation that the scam and sham plans had facilitated avoidance of the provisions as distinct from the effect of the Sale of Land Act. To demonstrate this, on the screen now is a part of page 35 of the transcript where Middleton submitted that the scam and sham plans did facilitate avoidance of the Sale of Land Act, and in reply Master Eftham agreed and understood the same. So again, in the face of the facts and the law, Middleton deceived the court. Now, photographs of the solicitors and barristers for the Council and Water Authority who were opposing Middleton are on the screen now. Now, as you will shortly see, they are a bunch of crooks, and I intend to see each and every one of them incarcerated. From left to right, in the top row, is the now Major General Justice Greg Gard, who at that time was a barrister, a Queen's Counsel. Then in the centre of the top line is his junior barrister, Sharon Burchell, and then solicitor Stephen Mark Edward. They were the lawyers for the Water Authority. In the bottom row, from left to right, is Jim Delaney QC, his junior barrister Greg Ahern, and solicitor Michelle Elizabeth Dixon, who I referred to earlier. They were the lawyers for the Council. Now, the solicitor for the Council, Michelle Elizabeth Dixon, was from the firm Maddox, and as previously discussed, Maddox was previously known as Maddox, Loney and Chisholm. Now, the crooked solicitors from Maddox have a long and sordid history in this matter. As I will discuss later, after the broader aspects of the conspiracy were described in Parliament, the then partner of Maddox, Ian Loney, met with the Water Authority members and with the Shire Engineer and the Joint Shire/Water Authority Secretary at 7:45 p.m. on the 10th of April 1986, and they jointly agreed on a scheme to deceive the then Minister for Local Government and the then Minister for Water Resources into believing that the things comprising the conspiracy were lawful and legitimate. They did then successfully deceive the ministers. Subsequently, Ian Loney communicated that scheme to the solicitor for the ANZ subsidiary, which I discussed earlier, John Norman Price, and to the now Major General Justice Greg Gard, and for the purpose of again concealing the conspiracy and perverting the course of justice, Price and Gard and Loney and the Council and Water Authority falsified documents and made overtly false submissions to an appeals tribunal. Then, after having perverted the course of justice to provide the appearance of legitimacy, an ANZ subsidiary knowingly sold land in what it knew to be the ongoing unlawful circumstances of the corruptly concealed conspiracy. Then Maddox were solicitors for the Council and Water Authority in the earlier county court proceeding, and as experts in local government law, they knew well that the Council falsified documents and made false defences and exhibited falsified documents in that proceeding. As you will shortly see, Maddox, and in particular their now CEO, Michelle Elizabeth Dixon, continued that tradition of corruption in the proceeding in present discussion, where Middleton was my barrister. As for the now Major General Justice Greg Gard, as I said, he conspired to deceive the tribunal, and then he and his instructing solicitor, Stephen Mark Edward, were lawyers for the Water Authority in the 1995 Supreme Court proceeding, which I mentioned earlier, and during which it was Stephen Mark Edward who visited my residence and stole my private brief to my earlier barrister. I subsequently learned that during that 1995 proceeding they also concealed documentary evidence which they had in their possession. So, now to return to discussion on the 2005 proceeding where Middleton appeared. Now Gard and Edward noticed that the brief for my 1991 barrister, which stolen by Edward, would be useful to them in that new proceeding, but they knew well that it was a private and confidential and privileged document which Edward had effectively stolen. So being the inveterate fraudsters that they are, they fraudulently fabricated a document to include that private privileged document and then misrepresented it and included it in their exhibited documents. And then Edward swore false affidavits to legitimise his possession of it. Now, to demonstrate that fraudulent fabrication, I'm about to play a clip from an earlier video which I made in respect of Gard's serial corrupt conduct. But first, on the screen now is an extract from Gard's written submission to the Master, and in that extract he refers to item 43 of SME 1 volume 2 of his and Edward's exhibits, and then he described it as being a true copy of my document entitled Book of Pleadings. Okay, so I will now run the clip, and I hope my countenance does not shatter your screens. These are the exhibits which Stephen Mark Edward and Justice Gard and Sharon Burchell put in. Now, SME 1 Volume 2 at item 43 is said to be a true copy of the plaintiff's document entitled Book of Pleadings. Now we'll see what really is the case. Now, in this document here, you can see that this item 43 of SME 1 Volume 2 is that thick. Now, that is a Book of Pleadings. Now, this separate document here, and I'll show you close-ups of these shortly, is in fact a document that was prepared in 1991 by me for the purpose of briefing and obtaining advice from my then barrister. Now, at the front of it, the front of this document contains a letter to my a note to my then barrister. In the back of this document here are the handwritten notes of my then barrister. Further handwritten notes of my then barrister. Now, he actually took this document into court with him back in 1991. Now, what in fact occurred was that Stephen Mark Edward dishonestly, or at least seriously improperly, took a copy of this document, this privileged private document. Stephen Mark Edward and Greg Gard had a serious problem. This was a confidential and privileged document which they could not get into court. So what these corrupt little fraudsters did was they took this genuine court document. Now it's a Book of Pleadings. Now every barrister understands what a Book of Pleadings is. A Book of Pleadings is a document which consists essentially of a cut and paste of a statement of claim and then the relevant paragraphs of the defence. See, here we have, for example, SC, Statement of Claim, paragraph 15. Here, AD, Amended Defence, paragraph 15. So it's a book of the pleadings. Now, because they could not get this into court, what these little fraudsters did was they took the copy of the pages of this document and they appended it to this document, appended those pages to this document, and then they fraudulently represented it as being a copy, a true copy, in Gard's words, Gard and Burchell and Edwards' words, of the plaintiff's document entitled Book of Pleadings. Okay, now I will just quickly show you close up and a few pages from that green folder so you can see that they are one and the same as I showed earlier when discussing that the Sale of Land Act cannot be avoided by scam and sham plans. Now, to legitimise his possession of that document, Edwards swore an affidavit where he said that it was a document discovered or exhibited by me during the earlier proceeding, and he further swore that he attended my solicitor's offices to examine and take copies of those supposedly discovered and exhibited documents. In reply, I swore an affidavit which said that he had in fact attended my residence. Edward then swore further affidavits saying that he had attended my solicitor's office. It was in the personal knowledge of my junior barrister and my solicitor that Edward's affidavits were false. They refused to state their personal knowledge and said that the court does not want to hear about that sort of thing. The Master accepted Edward's affidavits in preference to mine. I think it's significant that not even my solicitors would stand up at that time, and their statement that the court does not want to hear about that sort of thing is significant and a product of the culture which engenders corruption. Now, as I said earlier, the Council and Water Authority issued summonses seeking summary dismissal of my claim. For that purpose, they necessarily had to prepare a number of submissions and affidavits. Now, when someone brings a proceeding in court, it must be done with great particularity, and in the case of summary dismissal applications, they must identify the exact cause of action which they say offends the so-called statute of limitations or other grounds for summary dismissal, and then demonstrate that it offends the Limitation of Actions Act or whatever. Now, in this case, the lawyers for the Council and Water Authority did not have legitimate grounds for dismissal of my true cause of action, so they instead brought their application based on what can be described as a pseudo cause of action, and to refer to it they used euphemisms throughout their various submissions and affidavits. Now, to illustrate such euphemisms, on the screen now is an extract from one of my subsequent submissions in the Court of Appeal, and I will discuss that aspect later. Now, as you can see, in that submission, with footnote references to the relevant documents, I said, under the heading, the euphemisms keeping the strategy secret, and then starting at what was the paragraph 127, I said, despite having mounted strikeout proceedings on the express assertion that the cause of action in the proceeding offended either or all of the Limitation of Actions Act, res judicata or anshin, Dixon et al. Simply do not say what things constitute the cause of action complained of. The strategy depended upon having me and my lawyers think that they were referring to the true cause of action whenever they referred to the cause of action by use of phrases such as the claims sought to be advanced. Each time they used such a phrase, they were referring to the things constituting their pseudo cause of action. Whenever it was necessary to refer to the cause of action, Delaney and Ahern used phrases such as the following in their first outline. At Delaney's paragraph 66, the claims sought to be advanced. At their paragraph 36, fresh allegations. Paragraph 43, the claims made by the plaintiffs. Paragraph 52, the cause of action. Paragraph 54, the allegations in the omitted paragraphs. Paragraph 55, the events. Paragraph 68, the claims he now seeks to advance. Paragraph 70, the matters pleaded in the omitted paragraphs. And then I said, in their minds, however, these phrases were euphemisms for the pseudo cause of action. They knew that they understood one thing while intending and knowing that I and my lawyers understood another. Dixon didn't even use euphemisms. She just completely avoided any statement which would necessitate uttering or defining the things constituting the cause of action, even in her affidavit, which purports to support the strikeout application. Now, as you can see, those euphemisms don't say a damn thing, yet they formed the entire foundation of their summary dismissal applications. Now, as I now know, this tricky use of euphemisms had a profound effect. Namely, when I read their submissions and affidavits, I genuinely thought the euphemisms were referring to the matters and things constituting my true cause of action, while Middleton plainly thought that they were referring to the things constituting his grievous misunderstanding of my cause of action. So the fact is that the barristers and solicitors for the Council and Water Authority had brought scam and sham summary dismissal applications, which had no substance at all, and had no chance of success in an honest and competent court, but did give them the opportunity to get their talking heads in court and to extract some moolah from either me or their respective clients. So the fact is that Middleton's fabrications were the product of the combination of the scam and sham applications of the lawyers for the Council and Water Authority and Middleton's inherent criminal predilection. So at the hearing, the lawyers for the Council and Water Authority were first to speak, and they muttered for a day and a half without saying a damn thing of substance. The Master listened, but didn't once ask a fundamental question as to what constitutes my gravamen or cause of action. On the morning of the second day, Guard introduced the fabricated document, which they called the so-called Book of Pleadings, and very briefly referred to it. But because they had no actual substance to their dismissal applications, Guard made no specific allegations in relation to the content. Delaney and Guard may as well have read Donald Duck comics to the court for a day and a half. The Master would not have been any wiser. Then, in purported reply, Middleton made the fraudulently fabricated submissions which I have already set out in this video. Then, in reply to Middleton, the lawyers for the Council adopted Middleton's fraudulent submissions as constituting their euphemisms, and they relied on the so-called Book of Pleadings to make mincemeat out of and absolutely falsify Middleton's submissions. For example, as discussed earlier, and on the screen again, Middleton submitted that I did not know that each of the scam and sham subdivisions represented separate discrete subdivisions. Well, in reply to the fraudulent misrepresentations of Middleton, Delaney for the Council simply opened the so-called Book of Pleadings at page numbered 5. Now, I have placed the transcript of Delaney's reading of page 5 of the so-called Book of Pleadings on the left of the screen, and my handwriting on page 5 of the so-called Book of Pleadings to the right. Now, in the transcript, I have underlined Delaney's comments in blue and his reading from the so-called Book of Pleadings in red. Now, Delaney read the top paragraph of my handwriting, which said that Buchanan's sales were illegal. And then Delaney sarcastically said, "One might say, why is it illegal?" And then he answered himself by reading the first part of my next paragraph, which said, "in order to avoid the provisions of the Sale of Land Act." Then further sarcastic comment from Delaney. He said, "Isn't that interesting?" Delaney then read up to my words, "Buchanan then lodged." Then he sarcastically asked, "What did he do?" Delaney then answered himself by reading the part of my writing which gave the absolute lie to Middleton's submissions. That part said 7 separate plans which were contrived. Delaney then sarcastically commented, written in the plaintiff's own hand. Delaney then read, to create several subdivisions of 2 lots each. Then Delaney quite rightly and sarcastically said, this is a critical piece of information you're being told, that this poor man didn't find out until 2000 and didn't realise he had this great case. Delaney, of course, was quite correct with his sarcasm. Middleton's submissions were in the face of my handwriting and absolutely fraudulent. So, the fact was that the lawyers for the Council and Water Authority had brought scam and sham summary dismissal applications which were founded on euphemisms for my cause of action and which had no chance of success in an honest and competent court. And then the only thing of substance that they did was to abundantly show that fraudster Middleton had brought a sham and scam defence to their scam and sham applications. So, the incredible and palpable fact is that in that court we had a flagrant scammer facing off against a flagrant scammer, and the most flagrant scammer, Middleton, was the loser. Now, when I say incredible, the fact is that this type and class of corrupt conduct is not incredible at all. It is entirely predictable, because all of the scammers are assured that the entire justice system, from the Attorney General and Chief Justice and President of the Court of Appeal down, will deny and conceal their overt corrupt conduct. This was a classic case of the self-perpetuating carousel of crime and corruption and concealment in operation. 3 months after I wrote to Middleton and told him he was a fraudster, the silently complicit master published his reasons for decision on 15th of May 2006. Now, an extract from my letter to Middleton is on the screen now. In that letter, I said that failure was essentially assured and what he said to be a cause of action cannot even begin to form the basis of a cause of action. I further said that my only hope was if the master recognises the conflict between your submissions and my affidavit and the facts. I also said the other things which are on screen. Now, on the facts before him, it is simply not credible that the master did not know that Middleton had scammed me by bringing a palpably hopeless defence. Founded on the garbage put to him, the master's written reasons extended for 26 pages of nonsense, which merely demonstrated that he had neither the courage or integrity to stand up and say that Middleton was a scammer. In the face of the law, the master found against me because I knew that the plans were not lawfully sealed. The master may have well found against me because I had eggs for breakfast. Okay, now I will begin to get into the really serious material. As discussed earlier, after I wrote to Middleton and said that he was a fraudster, communication passed between Middleton and his instructing solicitor. An extract from that communication is on the screen now. Now, that document discloses that the Council's solicitors served Middleton with a copy of the so-called Book of Pleadings on the Friday preceding the Monday hearing. Now, the circumstances surrounding and following that service were as follows. I and my then partner were in Middleton's office at a supposed pre-hearing conference. As was usual, I was told to sit quietly and that Middleton would ask me questions if necessary. On that afternoon, I detected panic in discussion between Middleton and his junior barrister. Upon inquiry, I discovered that they had been served with the so-called Book of Pleadings, and they were concerned that it disclosed that I was aware that the plans represented several subdivisions. I also learned that they were concerned that I knew that the sham and scam plans were unlawful in that they did not show all allotments intended to be set out. Not being aware that Middleton had a complete misunderstanding of my case, I simply pointed out to them that those things were of no concern. At that time, I flew my own beautiful private aircraft, and that afternoon, while flying my then partner back home to Dubbo in New South Wales, she said to me to the effect that those pompous bastards took no notice of you. They weren't listening. She was a little bit more worldly than me. So I dropped her off at Dubbo and flew to Orange, where I lived, and hurriedly sent out an email to Middleton and his junior barrister. The header of that email is on the screen now, and as you can see, it was sent at 4:27 p.m. on Friday 11th of November 2005. The hearing started on the following Monday morning. The text of my email is on the screen now, and in essence it said, illegal sealing per se could not cause loss and damage. Section 569B10 operates so that there is no such thing as unlawful sealing. At the time of writing the books of pleading, I was aware that the plans were in breach of the law which required them to show all allotments. However, that knowledge was of no consequence. And most importantly, at the bottom, my email said, the things which caused my loss and damage is that the notice of requirement which purportedly issued had no authority of law, and the council sealed the plans in knowledge of that fact, and the council sealed the plans in breach of their statutory duty to refuse to seal them. At that time, Middleton had my copy of the Local Government Act, so the email mistakenly said 56910 rather than 569B10. So, the palpable documented facts are: Middleton was served with a copy of the so-called Book of Pleadings on the Friday before the hearing. He and his junior barrister had read its contents and had panicked because it gave the lie to Middleton's intended submissions in respect of his misunderstandings of my cause of action. I responded to his panic by sending an email which addressed his reasons for panic. Middleton either ignored my email or could not assimilate it with his misunderstandings. Then, in the face of the facts and the law and the so-called Book of Pleadings, Middleton made the fraudulent submissions which I set out earlier. Of significance is that on each occasion I met with Middleton, I was told to sit quietly and he would ask questions if necessary. He never did. It is now obvious that Middleton intended to scam me and avoided speaking with me. On his mistaken understanding, Middleton had a duty to advise me that my case, as understood by him, was hopeless. That duty exponentially compounded once he was served with and panicked at the so-called Book of Pleadings. His eye was on my wallet, and he wasn't going to let a little morality and honesty get in the way. Now, the further exceedingly serious thing which was set out in the original letter between Middleton and his instructing solicitor is on the screen now. As set out in that extract, upon receiving judgment from the Master, the solicitors for the Council and Water Authority applied for and were granted punishing indemnity costs orders against me for having brought a claim which had no chance of success. That extract also sets out that the solicitors for the Council intended to make application for an order that Middleton's instructing solicitors pay all costs on the basis that this was a case which had no prospect of success and should never have been brought before the court. At that time, the solicitors for the council were not aware that Middleton had misrepresented me. They instead thought that I was an honest but misguided person, and that Middleton had put my, in fact, hopeless case. That was a classic instance of the legitimate but hopeless claim or defence which I discussed earlier in this video, and where the court would make such costs orders against the lawyers. Significantly, the instructing solicitors said that if such application was made, they may well require Middleton's further assistance. So, Middleton had my demand that he appear at my inevitable appeal and explain his shortcomings, and he had his instructing solicitors ask that he assist if application for costs orders were made against them, because the solicitors and Middleton had brought a hopeless case. So, the inescapable conclusion is that the lawyers for the Council and Water Authority knew well that Middleton had intended to scam me by getting his talking head in court and putting what he knew to be a hopeless case. Now, in this regard, it is important to note that the solicitors concerned were classic country bumpkin solicitors, and quite early in preparation I wanted to sack them as being hopeless. At that time they wanted $100,000 for work done to date, but shortly afterwards they secured the services of Lex Lazary. With Lex Lazary at the helm, I was happy to proceed with them. I am quite sure that they absolutely relied on Middleton once he was retained. Okay, so now we begin to get to the really serious stuff, namely judicial corruption. Shortly after Master Etham published his reasons for decision, I filed a notice of appeal. Now, an appeal from the orders of a master was one of right, and there was no need to set out any grounds of appeal. Such an appeal was heard by a full judge of the Supreme Court and was conducted as a so-called rehearing de novo, or in other words, a new hearing, or in other words, the hearing before the full judge was as if the hearing before the master had not occurred. Now, at that time, I had not yet appreciated that the lawyers for the Council and Water Authority had brought scam and sham applications based on euphemisms, as I have discussed earlier in this video. At that time, my understanding was that the lawyers for the Council and Water Authority had identical misunderstanding of the facts and the law as Middleton did. So, because the lawyers for the Council and Water Authority had to speak first and make their case, I was confident that they would repeat what they had put to the master when debunking Middleton's submissions before the master. I prepared an appropriate written reply in advance. The hearing came on before Justice Robert Osborne on 31st of October and 1st of November 2006. So, at that hearing, the lawyers for the Council had made substantially amended written submissions where they replaced what I later learned to be the euphemisms with the garbage which they had purloined from Middleton and then put to the master. The entire case put to Osborne by the lawyers for the Council and Water Authority was encapsulated in paragraph 82 of their amended submission, and that paragraph is on the screen now. Now, that paragraph completely encapsulates and regurgitates the garbage that they purloined from Middleton's fabrications and then put to the master. As you can see, underlined in red and blue, they said that my cause of action was that the initial sealing of the plans of subdivision was unlawful, and that the plans were sealed in such a way as to avoid the operation of Section 9 of the Sale of Land Act. In the heading to that paragraph, underlined in orange, they said that these things are set out in the so-called Book of Pleadings, and were known to me when I prepared the so-called Book of Pleadings in 1991, and were not concealed from me. So, as I discussed earlier, at law, there was no such thing as unlawful sealing of plans of subdivision, and the operation of the Sale of Land Act could not be avoided by scam and sham plans, or at all. So, the entire case put to Osborne by the Council and Water Authority was a repetition of the fraudulent misrepresentations made to the Master, and were in the face of the facts and the law. In reply, I was fairly frank and hard-hitting. Firstly, in genteel terms, I set out that Middleton had scammed me by making submissions which were in the face of the facts and the law, and that he had misrepresented me and my case. I then pointed out that on the garbage put to him by 3 QCs, 3 junior barristers and an army of lawyers, and on the mistaken view of the Master, my true case was neither put nor argued against or adjudicated on. I also said the self-evident fact that the lawyers for the Council and Water Authority do not and cannot hold a belief as to the truth of their submissions. Probably, most significantly, I repeated that Middleton had scammed me. I particularly said that he could not possibly have held a belief that I would succeed on his submissions. Unfortunately, he did not tell me so. I then said that by saying this, I may have raised a bar which I must now clear. However, the facts, unfortunate as they may be, are the facts. Now that last part by me, that was an obtuse reference by me that Osborne would need to be a courageous judge, because a judgment in my favour would, by implication at least, uphold my most serious allegations against Middleton, who by that time had been appointed a federal court judge. Before going to court, I told my friends that I would need a particularly honest and courageous judge. I soon learned that Osborne was not such a judge, and as I have subsequently learned, none of them are. So, after my submission, the lawyers for the Council and Water Authority knew well that Middleton had not simply brought a legitimate but hopeless case on behalf of an honest but misguided client, that is me of course. He had instead committed the worst type or class of corrupt conduct. He had intended to outright defraud me by bringing a fraudulently manufactured case which flew in the face of the facts and the law and plain common sense. In addition, after my submission, the lawyers for the Council and Water Authority knew well that the case which they had purloined from Middleton was also in the face of the facts and the law. So, after my submission, Osborne was well aware that the lawyers for the Council and Water Authority and Middleton were nothing more than a bunch of crooks. On the second day of hearing, after I made my submissions, the bile and vitriol of Osborne was palpable. On that day, I knew that Osborne was neither an honest or courageous judge, and I knew I was done for. By about the middle of that day, it was apparent that Osborne had already decided to find against me, and to protect Middleton and the lawyers for the Council and Water Authority. An observer in the court whispered to me, "You're done for." Okay, now I will teach you exactly how Victorian judges do fraud and sacrifice your democratic rights to protect the sham good name of the court and their corrupt mates. Osborne published his purported reasons on 29th of November 2006, and because I was absent on that day, he adjourned the court until 7th of December for orders. Now, manifestly, Osborne could not summarily dismiss my claim on the garbage put to him by the lawyers for the Council and Water Authority. So Osborne first had to concoct a way or method or scheme where he personally could sit in his office and concoct and introduce and fabricate grounds to find against me. That method is found in paragraphs 87, 88 and 89 of his purported reasons, which are on the screen now. In those paragraphs, Osborne said that I appeared in person on the express basis that my claim was not correctly articulated by Middleton. He then said that I invited him to adopt a different framework of analysis than that put to and decided by the Master. He then said that the lawyers for the Council said that Osborne should give weight to the Master's decision and the Master's findings of fact after extended argument and examination of evidence over several days. Osborne then said he had sought to deal with the matter on the basis now put to him by me. He then said that he proposes to deal with the matter on the basis that the case put to him by me is the case to be considered, rather than that previously put to the Master by Middleton. Now all of that was purposely fabricated nonsense, and any judge or barrister reading it would instantly recognise it as such. The simple fact was that the proceeding before him was the rehearing de novo of my defence to the summary dismissal applications of the Council and Water Authority. The fact that the defence put to him by me was different to that put to the Master by Middleton was entirely irrelevant. Osborne had no choice other than to adjudicate on my then defence to the palpable garbage put to him by the lawyers for the Council and Water Authority. By those purposefully formulated and fabricated paragraphs, Osborne concealed the fact known to him that Middleton and the lawyers for the Council and Water Authority had put garbage to the Master, and the Master had adjudicated on that garbage. By those paragraphs, Osborne opened the way for himself to sit in his office and personally introduce matters and things which were not submitted to him and not in evidence before him. Osborne then did sit in his office and did personally introduce matters and things and fabricated his purported reasons around the things invented by him without trial. Osborne's purported reasons opened with a corrupt bang, so to speak. Osborne's paragraphs 4, 5 and 6 are on the screen now. At those paragraphs, under the heading Factual Background, Osborne concealed the things giving rise to my true cause of action by essentially repeating and representing as fact the fabrications by which the Shire engineer had duped the councillors and deceived the magistrate and Justice Kay and me. Now, as you can see, at his paragraph 4, Osborne correctly says that on 20th February 1980, the Council resolved to impose a requirement, but then he fraudulently says that the Council resolved to seal the legitimate plans on that day. Then at his paragraph 5, Osborne fraudulently says that Buchanan submitted for approval a series of plans which were in effect stages of the previously proposed subdivision. In essence, Osborne's paragraph 5 is an exact repetition of the fraudulent and perjurious representations which deceived the councillors and the magistrate and Justice Kay, namely that the sham and scam plans were parts of the legitimate plan. Significantly, Osborne's paragraph 5 says that Buchanan submitted the series of plans for approval, whereas the fact known to Osborne was that they were filed for the specific purpose of avoiding the approval process, and with the connivance of the Shire Engineer and Shire Secretary, they did avoid the approval process and were never either considered or approved by the Council. Then at his paragraph 6, Osborne overtly fraudulently represents that the Council officer then endorsed the plans as subject to the requirements originally imposed by the Council with respect to the legitimate plan, which Osborne refers to as the global plans. Significantly, Osborne's paragraph 6 conceals that the Shire Engineer and Shire Secretary fraudulently destroyed the legitimate plan and then fabricated notices of requirement in respect of each of the scam and sham plans, and endorsed the scam and sham plans, knowing full well that they were separate, discrete subdivisions which were not subject of or related to the resolution of the Council to impose road-making requirements in respect of the legitimate plan which had been destroyed. By those paragraphs, Osborne exactly repeated the perjury by which the Council concealed the true facts from the courts and myself. By those paragraphs, Osborne intended to conceal and did conceal the true facts, including the corrupt conduct in earlier courts, from the people of Victoria. None of that material was in submissions to or evidence before Osborne. Osborne sat in his office and concocted those things. He obtained the essence of his paragraphs 4, 5 and 6 from my affidavit, where those things were set out as constituting the perjurious representations of the Shire Engineer. Osborne then fabricated his reasons to conceal my true cause of action in the identical manner as the Shire Engineer did with his perjury. As I will shortly show, the purpose of concocting those paragraphs and concealing my true cause of action was in order that he could then fraudulently represent that the fabrications put by Middleton and by the solicitors for the Council and Water Authority were true and legitimate, and thereby falsify my allegations against each of them. As I alluded to earlier, Osborne speaks with the authority of a judge of the Supreme Court of Victoria. I trump him by speaking the simple, palpable truth. Manifestly, Osborne fabricated that garbage in knowledge that the people of Victoria would not know that he was referring to the scam and sham plans, which were all sealed by the Council on one day, and all filed with the Titles Office on one day, and all approved by the Titles Office on one day, and manifestly were not and could not be construed to be stages. He knew well that anyone who did look at the plans, including his fellow judges, would know well that he was lying when he said that they were stages of the legitimate plan. He also knew that the lawyers for the Council and Water Authority would instantly recognise that he had fabricated those purported facts for the purpose of concealing their own and Middleton's corrupt conduct. The entire balance of his purported reasons depended upon him first concealing the true facts known to him. Now, the essence of the entire balance of Osborne's fabrications is found at paragraph 58 of his purported reasons. In that paragraph, Osborne refers to my earlier county court proceeding, and he fraudulently says that the statement of claim in that proceeding specifically alleged that the plans were not lawfully sealed and lawful notices of requirement were not issued. Then at his paragraph 60, Osborne says that each of those allegations form part of the subject matter in my new 2005 proceeding. Osborne then says that the critical allegation in my new proceeding is that the council did not serve proper requirements. Now, the reason for Osborne making those representations is that if a particular thing has been or could have founded a claim in an earlier proceeding, then a person is quite rightly barred from founding a subsequent claim on those same things. So now we shall look at the truth of the two supposedly founding things set out in Osborne's paragraph 68. Well, the first one is simply manifestly false and in the face of the law. Back at the time of the county court proceeding, I and my then barrister knew well that at law there was no such thing as unlawful sealing per se, and the simple fact is that unlawful sealing per se was not alleged in the earlier proceeding or in my new proceeding. That is a manifest, in-your-face, fraudulent fabrication by Osborne. Now, the second allegation by Osborne is a fascinating one and demonstrates the gross and crass extent to which a corrupt judge will go to protect the court and its mates. You will recollect that the proceeding before the magistrate and Justice Kay were on the question as to whether or not I was liable to pay the council the costs of it making the roads. Now, the law empowered the council to impose a requirement that the developer construct the roads, or impose a requirement that the developer pay to the council the costs of the council making the roads. As is obvious, those two things are mutually exclusive. In the proceeding before the magistrate and in the appeal before Justice Kay, in the face of the facts, the council fraudulently represented that it had made a requirement that the developer pay the council the costs of the council constructing the roads. Justice Kay adjudicated on that specific point, and the relevant part of his reasons is on the screen now. In that extract, Justice Kay set out that there was the two types or classes of requirement, and at the top, underlined in red, Justice Kay said that the requirement imposed on Buchanan was to construct the roads. Then, in the extract which is on the screen now, Justice Kay said that the magistrate's finding that the requirement was a requirement that Buchanan pay the council the costs of constructing the roads was in conflict with the express terms of the requirement. In simple terms, Justice Kay expressed the palpable fact that the requirement imposed on Buchanan was a requirement for Buchanan to construct the roads and was not a requirement that Buchanan pay the council the costs of constructing the roads. Then, relying on the express reasons of Justice Kay, I issued the county court proceeding to recover the money paid to and had and received by the council under mistake of law. The mistake of law being that the requirement served on Buchanan was a requirement to construct the roads and was not a requirement that Buchanan pay the council the costs of the council constructing the roads. In fact, of course, there was no mistake of law. The council was committing deliberate fraud, but I could not say or allege that at that time. In exact accord with the reasons of Justice Kay, paragraph 7 of my statement of claim in the county court specifically alleged that a notice of requirement requiring construction of the roads was served. Then, in continuing accord with Justice Kay's reasons, paragraph 20 of my then statement of claim alleged that there was no requirement empowering the council to claim the costs of it constructing the roads. So, in essence, my county court proceeding alleged that the council did impose a requirement for the construction of the roads and did not impose a requirement that it be paid the costs of it constructing the roads. So, for the purpose of his criminal intent, at his paragraph 56, Osborne transcribed paragraph 20 of my earlier statement of claim into his reasons, and then fraudulently relying on that transcribed paragraph, Osborne said that the statement of claim in my earlier proceeding specifically alleged that lawful notices of requirement were not issued. By that representation, Osborne intended to fraudulently convey, and did fraudulently convey, that my earlier statement of claim specifically alleged that there was no lawful requirement for the construction of roads. That was an overt fraudulent misrepresentation by Osborne to deceive the people of Victoria and to protect his and the court's corrupt friends. Osborne's purported reasons then rely on that fraudulent fabrication to summarily dismiss my 2005 proceeding. Now, as I said, Osborne published his purported reasons on 29th of November 2006, and because I was absent on that day, he adjourned the court until 7th of December for orders. During that intervening period, I prepared a fairly frank written set of allegations which, with particulars, alleged that Osborne was corrupt. I presented that set of written allegations at the hearing of 7th of December 2006. Paragraph 2 said, "As a matter of demonstrable fact, your substantive reasons for judgment are manifestly wrong and without any basis in fact or reason." Paragraph 4 said, "I would be appealing his judgment." Paragraph 17 said that I place on record that I was seriously concerned and disturbed by his reasons for judgment and the facts and circumstances surrounding that judgment and the circumstances of his conduct of the hearing. Now, my viewers, take note of my paragraph 24, which is on the screen now. The things set out in that paragraph become very important in the subsequent corrupt Court of Appeal hearings. In that paragraph 24, I pointed out that the rules of the Court of Appeal required that the lawyers for the Council and Water Authority compile a summary of the court proceedings and a summary of the facts. I then pointed out that the summary of facts would necessarily be at odds with the facts set out in Osborne's reasons. In other words, I pointed out the self-evident fact that the summary of facts would expose Osborne's corrupt conduct in the Court of Appeal. After I gave that set of written allegations, Osborne said that there was no need for the lawyers for the Council and Water Authority to reply. Then, relying on what they knew to be purported reasons, which had been contrived to conceal their own corrupt conduct, the solicitors for the council and water authority made submissions that Osborne should make punishing costs orders against me for having brought a hopeless case to court. Osborne did then make orders summarily dismissing my claim and that I pay punishing indemnity costs. That was a clear case of court-ordered extortion. I then had 14 days to file an appeal with the Victorian Court of Appeal. On the last possible day, 21st of December 2006, I filed my notice of appeal. In essence, my notice of appeal alleged that Osborne had fabricated his purported reasons, and the lawyers for the council and water authority were well aware of that fact. The first occurrence in the Court of Appeal was that the court fabricated and uttered the fabricated order and fabricated authenticated order document which I referred to at the beginning of this video and which is back on the screen now. Now that document represents that the orders set out in that document were made on 29th of November 2006. Now the first thing to observe is that the supposed Order 1 on that document is manifestly not an order and cannot be construed to be a legitimate order of any court at all, let alone an honest and competent court. That purported order is that my appeal should be dismissed. Well, it's obvious that should be dismissed is not a definitive order. Should be includes that it may not occur. So, on the screen now is the transcript from the 7th of December 2006 hearing. And as you can see, underlined in red, blue and green is the three orders which were in fact made on 7th of December 2006. And the first of those orders is the clear order that my appeal be dismissed. Now on the screen now is a transcript from the 29th of November when I was not present, and as you can see the only order on that day was the adjournment until 7th of December. Now on the screen now is the letter from Guard's instructing solicitor where they served me with a copy of that fabricated authenticated order document. In that letter, Stephen Mark Edward, the author, fraudulently relies on that fabricated authenticated order document and represents that my appeal was filed out of time from the orders of 29th of November 2006. Now, I remind my viewers that Edward was the self-same person who stole my brief to my earlier barrister and then conspired with the now Major General Justice Greg Guard to fabricate the so-called Book of Pleadings. Now this video is already becoming too long, so I am going to skip the detail of how I confronted the court and overcame that fabricated authenticated order. However, take note, this is a corrupt court in action. The next occurrence was that the lawyers for the Council and Water Authority made application that I provide security for their costs in the appeal. That application came on before Justices Buchanan and Redlich. My defence was that due to the circumstances of my appeal, namely corruption in the court itself, I was entitled to appeal as a matter of basic human right. At that time, I further alleged the fact of the fabricated authenticated orders. In knowledge of their corrupt conduct and that Osborne had fabricated his reasons to protect them, the lawyers for the Council and Water Authority relied on the judgments of both the Master and Osborne. From the papers and the fact of the fabricated authenticated orders, Justices Buchanan and Redlich were well aware that my appeal was not without substance. They ordered that I pay $60,000 into the court, and in default my appeal would be dismissed. I paid the $60,000 in cash. Next came a directions hearing before the now Associate Justice Lansdowne. At that directions hearing, I submitted that the summary of facts which the lawyers were required to prepare would limit the complexity of further conduct of the matter, and I asked that she make orders that the lawyers for the Council and Water Authority compile the summary of facts required by the court rules. From the papers and from the fact of the fabricated authenticated orders and from my submissions to her, Associate Justice Lansdowne was well aware that the summary of facts could or would expose the corruption alleged and evinced by me. The lawyers for the Council and Water Authority submitted that they should be excused from compiling the summary of facts. Lansdowne made orders excusing the lawyers for the Council and Water Authority from compiling the summary of facts. Master Lansdowne was well aware that her orders destroyed an opportunity that could or would expose the corruption alleged by me. At that time, it became abundantly clear that I was on a fool's errand in believing that the Court of Appeal, or any judge for that matter, would expose their corrupt friends. Shortly afterwards, I decided to stop throwing money away, so I abandoned my appeal. At a subsequent court hearing, before Justices Neve and Mandy, I said the things which are on the screen now. I said that so long as barristers such as Guard lie to the court with impunity, then this is not a place to seek justice. I also said that I abandoned the appeal in favour of going public to expose the corruption in the court. I then said that I had reserved the web domain name courtsontrial.com for that purpose. I then said that truth and fact are far more powerful than any judgment of this court. I then said that so long as barristers can mislead this court with impunity, the court is a sham. I then essentially repeated those things before Justices Redlich and Beach. Subsequently, each of Neve and Mandy and Redlich and Beach published reasons for judgment which contained essentially identical misrepresentations which denied my allegations. The extract from Redlich and Beach's purported reasons are on the screen now. In that extract, they say that I made a number of serious allegations against Osborne and the lawyers. They then said that my allegations involve a serious misunderstanding of the evidence and its legal implications. They then said that I had not advanced any written or oral submission which might on any view support my allegations. The fact is that they were bald-faced lying for the purpose of deceiving the people of Victoria with utterances made with the authority of a judge of the Supreme Court. The simple fact is they were aware of evidence which could give rise to a belief that serious judicial and other corruption had occurred, and whether or not I had abandoned my appeal, they had a duty to the people of Victoria to investigate and ensure the integrity of the court. They chose not to. To a man and woman, the judges of the Supreme Court and the Court of Appeal chose to sacrifice my democratic rights to their perception of the greater good, namely maintaining the sham good name of the court and themselves by concealing the endemic and systemic corruption known to them. They epitomised the self-perpetuating carousel of crime, corruption and concealment in operation. Now, This video has grown a little longer than I initially anticipated, so I will expose the further and substantially more serious corruption in subsequent videos. Now, Victoria has a new Chief Justice and a new Attorney General. Respectively, they are Anne Ferguson and Jill Hennessy. Now, as is obvious, no self-respecting court, Chief Justice or Attorney General can allow this video to go unanswered. The present question is, how will they respond? Now, you can be assured that their first priority will be an attempt to silence and perhaps even incarcerate me, and to allow the carousel of crime, corruption and concealment to continue and accelerate. Their second option will be to simply ignore this video and hope that it does not attract too much public interest. If they do simply ignore it, then that will provide sufficient evidence of their predisposition to not address the carousel of crime, corruption and concealment. If they do simply ignore it, then the public can rightly assume that the carousel continues and all civil judgments made into the future until they do address the carousel will rightfully be brought into question and suspicion. Significantly, if they do address the carousel and the court and its judges and barristers are seen to address corruption in their ranks, then the courts and justice system generally will rightfully enjoy a higher public confidence than presently imposed from on high. My expectation is that at least Justice Robert Osborne, Major General Justice Greg Gard and Justice John Middleton are removed from office and incarcerated. I also expect each of the lawyers involved to be disbarred and incarcerated. I will settle for nothing less. This video will be available from a link on my website. The fact of this video will be communicated to all named in it and to the various interested government departments. Visit my website for updates as to progress in excising the corruption. Thank you for watching. The end.